ever so lucky to have with me Mandy Haberman, founder of Haberman Global Innovations Limited. Haberman Products was created when Mandy was forced to innovate in order to feed her daughter, who had been born with particular feeding difficulties. Since then, Haberman feeding products have been used worldwide in both medical and mainstream settings. Mandy has faced numerous legal battles with regard to the intellectual property of her designs, and as such is well placed to give us an insight into the mechanics of how individual innovators are able to compete with large companies. Mandy, thank you so much for talking to me today. First of all, could you tell us a little about what drove you to create your first product, the Haberman Feeder?
The Haberman Feeder was created really out of necessity. My youngest daughter was born with a particular syndrome, Stickler Syndrome, and she experienced very severe feeding problems and a whole load of other problems as well. But when she was born, we tried every way of feeding her. She could not breastfeed, and none of the bottles seemed to work. She couldn't manage them at all. And in the end, she ended up being fed with a nasogastric tube, which is a tube that goes up the nose and down to the stomach. But in those days, you couldn't take babies home from hospital unless they were feeding by mouth. They wouldn't let you home with tubes in. So it was really down to me to improvise. And that was really, that improvised solution was the seed of my first invention, which was the Haberman Feeder. So I improvised for her and I came up with something which worked, which was she needed to suckle and I needed to get the food into her. So I took a syringe full of milk and she sucked on the dummy, and I cut off half the flange of the dummy. So she sucked on the dummy and I was able to put the milk in through the corner of her mouth. And that principle was behind when I decided to create an actual product to help other babies that had feeding problems for a whole variety of reasons. It was that principle of allowing the baby to suck, but also being able to put the milk into the baby's mouth. And that was the whole sort of seed of the idea for the Haberman Feeder.
Thank you, Mandy. So could you give us an idea? What are your reflections on that particular or your particular user experience as a source of innovation? So do you think that the necessarily deep level of knowledge that you have of the needs of your market have helped to ensure a wider and a faster diffusion of your innovations?
I think it's very helpful and very important to have a deep knowledge of the background to the products that you create. Because for me, anyway, I really understood, I've learned a lot about how the physiology of how babies feed. I've learned about the practical problems as a mother, the practical problems as the baby, and all of the difficulties. I really deeply understood the problem. I also, by getting so close to the problem and understanding that, I had researched to find every single type of feeder that I could find that might help my daughter Emily to feed, and nothing worked. I mean, I'd even gone as far as getting lamb's teats from the local vet. You know, I tried everything that was out there, and I knew that nothing worked. So I had, effectively what I'd done was to research the market. So when I came up with a solution or the seed of an idea that worked and solved the problem, firstly, I knew there was nothing else out there in the market that fulfilled this need. So I knew, I mean, I didn't sort of, at the time, I didn't think, I see a gap in the market. It was only, I started working on it when my daughter was 2. But having found a solution, I felt like I had a responsibility to create a product, because there was nothing out there for babies with feeding problems. So effectively what I'd done, I had researched the market. I knew there was a gap in the market. I understood there was a very significant need for this product. Yes, it was a niche market, but the need wasn't being met. So that understanding of the problem helped me to understand this was an opportunity. I mean, I didn't label it as, oh, I can see an opportunity. I just felt, I've got to get, I found a solution. I've got to get something out there to help other families. So commercially, you know, now looking back and knowing about business plans and knowing how you're supposed to research the market and what you're supposed to do, I had done it all inadvertently, but I had that background knowledge. And I think that, well, certainly when I came out with a product and I started to introduce it to hospitals, it got taken up, even though I wasn't a medical supplier, even though I didn't have any medical training, but I was allowed to go into hospitals. I was allowed to sit with mums, and hospitals then started buying from me by mail order because there wasn't anything else. And this was a product that solved those problems. So I think, you know, it's kind of odd in a way because, you know, nowadays you do a business plan, you know all the right words, you know what you're supposed to do. And this had all happened almost accidentally, if you like. I'd done all the right things by accident. And because there was nothing, this is the important thing, there was nothing else out there. So I had a product which had a USP, and it was fulfilling a real need and a gap in the market. So yes, it started to sell. It went worldwide. And this was back in the 1980s. And it's still used in hospitals today all around the world. I meet people from all over the place. I met somebody from Australia who was a speech therapist, and I introduced myself, I'm Mandy Haberman. What do you do? I'm an inventor. Oh, what have you invented? And I said, well, I did this thing. You might have come across as a Haberman. You're Haberman, you know. I mean, it's that kind of response. And that's like 35 years later. It's longer. Oh, gosh. Yeah, so it did make an impact.
No, I mean, it's extraordinary, really. I think to move on slightly onto your next innovations and sort of the next part of your journey, you've written quite a lot about your David and Goliath type experiences of taking on bigger players in order to defend your intellectual property. What lessons might you pass on to people stuck in that situation today? And in particular, how did you balance keeping your fledgling business going alongside managing the time and resources required to maintain a legal case?
It was a very difficult time. And you have to understand, I'm a very quiet person. I shrink from confrontation. And if you'd have said to me, you know, you're going to go to the high courts and battle out to defend your patent rights, I would have just laughed in your face. I mean, absolutely no way. I would have done anything else but do that. But I think, well, certainly I learned a lot about myself during this process. Firstly, it was a very difficult decision to go to court because certainly in the UK, in the high courts, the loser has to pay both sides costs for a start and damages. So to go to the high courts with a case, you're not looking at a few £100s, you're looking in the millions. You know, so if I had have lost this case, we would have lost our house. We would have been completely bankrupted. The kids would have had to have come out of the schools they were at. It would have been a total nightmare. And firstly, the decision of actually going ahead to do it. I mean, we'd sat round the table with the opposition. We had tried to settle and resolve this dispute, but it didn't work because it didn't balance out. I mean, what they were prepared to pay and what the potential of the product was, it would have just been a big loss for me. And a lot of people that I had working in factories and things would have been made redundant, and it was a disaster. But I suddenly had this sort of blinding flash that if I realised that if I didn't enforce my rights against this company, which was the first one to infringe, then all of the other companies would infringe as well. And I wouldn't have a business anyway. So actually, there wasn't a choice. So that's the first point. It's a very difficult decision to make. But when it came down to it, I really didn't have a choice. I had to do it. And for a fledgling company, I started out, I had legal costs insurance, legal costs IP insurance. I thought, that's fine, I've got insurance, I can do this. So I went along to my solicitor, and I very soon realised that the level of insurance that I had was nowhere near adequate to cover. I mean, I had a couple of £100,000 worth of cover, and what I needed was a couple of £1 million worth of cover. So it really was putting everything at risk. So that was the first sort of shock. But for a fledgling business, the only asset that I really had was my intellectual property. And if I didn't defend it, I didn't have anything anyway. So it was a very hard decision, but it was the only decision that I could make in the end. But things are a lot easier now because there's so many alternatives. I had to go to the High Court because I needed a speedy resolution, because the company that had infringed my patent was, well, it was Tommy Tippy. You know, it was at that stage they were the market leader in baby cups. And whilst we had already captured quite a big chunk of the market very, very rapidly, when they came out into the market, which was only about 18 months after I'd launched, they came out in the market with their product, which was based on my early prototype, actually. They took almost like 2/3 of our sales overnight. I mean, we couldn't survive alongside a big brand selling the same product, or product that came to be the same. So we had to do something. And yes, it was very, very stressful. But fortunately, I wanted to get something called an interlocutory injunction, which is so that they're stopped straight away, so that they don't ruin your market, they don't steal all your sales. But the judge said to me, if you do that, then you will be liable for damages if it turns out that they're not infringing your patent. So he said, what I'll do instead, I'll give you a speedy trial. And that meant we only had to wait a few months to get to court rather than waiting, you know, a year and a half or something. And we had 4 days in court. And thank God we won. I mean, it was a great outcome. And they still put in an appeal, and that's 18 months. But when it got to a few days before the appeal hearing date was due, Tommy Tippy actually settled, and that was that. But yeah, I wouldn't advise, if you have a dispute, if somebody infringes your patents and they pinch your product, the best thing that you can do is to get them round a table and negotiate and settle. And now there are so many more, there are so many easier, less traumatic ways of doing this. Firstly, the Intellectual Property Office offers a service on opinions. So they will give you go with your opponent. Your opponent has done as much digging as they can to try and knock your patent out. You sit in a hearing at the Intellectual Property Office, and they decide, firstly, whether your patent is still valid in the face of everything that your opponent has brought up. And then they decide whether your patent is infringed. It's not legally binding, but it means that you can then get round the table, because if your opponent, the patent office says you're infringing this patent, they're very unlikely to want to battle it out in court because it's expensive for them as well. So this is a very good way of getting an upfront decision, which you can then use to sit round a table and mediate or use alternative dispute resolution to find a settlement that's agreeable to both parties. And there's two other things. The Enterprise and Intellectual Property Court is a sort of quick fix. It's much cheaper. It's a bit like the county court compared to the High Court. It's a cheaper thing, and the damages are capped, and each side, I think, pays their own costs. But that's a much quicker way of getting justice, and it's much cheaper. Failing that, for people that really can't afford to do that, even that, there is now, the judges launched a couple of years ago something called IP pro bono, which I think is fantastic because it fills the gap. It means that people with no resource whatsoever can go and get advice and can potentially get to a resolution without having to fork out vast sums. But I think you have to be, they will look at your situation and decide if IP pro bono is appropriate. So there's a lot of other ways now to reach a resolution.
Gosh, yes. I mean, that is incredibly valuable advice for anybody else going through this. And much of that wasn't around when you were having to face your huge decision about whether to take this on.
That's right. I mean, there was the Patents County Court, which is now called the Enterprise and IP Court, but it wasn't so well run. And also, they had a huge backlog at the time, so it would have taken a long time to get to a decision. So that wasn't viable, and I needed a speedy resolution. So that all pushed me into the high courts. The other thing that I should mention is that my going to court and enforcing my patent rights, I think, illustrates that the patent system does work, even if you're the little guy up against a huge company. It's just having the bottle to see it through. But I think the other thing which I have to emphasize is that there's lots of different types of intellectual property. Patents is just one, and patents is possibly the most complicated, I think. A patent protects a concept of how something works. It's not what it looks like particularly, but it's how something works, so it's quite broad. So it's a good protection to have. It's a good intellectual property. The problem with patents is they're very volatile. You know, you have a patent, your patent gets granted, and you think if you have a granted patent, that's it. You know, it stands up, it's concrete, it must be fine. But the reality is, validity of a patent is only really tested when it's challenged in court. So the patent office they'll look at, they'll do all of their searches and everything else to the best of they do what they can within the resources that they have. And they will decide whether there's something else out there which is prior art and you shouldn't get a patent, or if they can't find anything and think, yes, you have a patent, you can have a patent granted. So it's a good search, but a company who's infringing your product, they have an incentive to try and knock your patent out. So they're going to do much more digging. They will look for prior art. They will look for things that possibly the examiner hasn't seen. They will also look at all of the filing, the letters, the backwards and forwards, the whole file. And there can be a word in that file which makes the whole thing fall down. And I've had experience of this. I enforced my patents in the United States against Playtex and against Gerber. Playtex knew they were infringing because they bought product from me in the very beginning. And they settled on the steps of the court. So that was fine, and that was actually a very nice settlement. But Gerber didn't want to settle. They didn't make a sensible offer for settlement. And it went to court. And it turned out that the US agent that my UK patent agent had used, so I'd been liaising with my UK patent agent. He had appointed a US agent to deal with things in America. He had sent a letter to the examiner making an argument that we hadn't asked him to make. But that argument contained a sentence that completely compromised my American patent.
Gosh.
I mean, I didn't know it was there. I didn't even know he'd made that argument. But it gave the other side fodder to create an argument. And as a result of that, instead of getting a straightforward, your patent is valid and infringed, that result came back as your patent is valid but not infringed.
Right.
So, you know, that was a major, well, it was a huge blow. I mean, I should have had a settlement of many millions of dollars. And in the end, we both walked away. It ended up as a stalemate in the end after appeal. But it just shows that there can be just some tiny thing in a patent that throws the whole thing upside down. And that's why my advice is very strongly create a wall of intellectual property around your business. Don't rely on patents, because patents are volatile. They can be there one day, they can be knocked out the next. Brand is hugely important. Have strong trademarks. Back up your patents. Register your design rights. As many trademarks, shape trademarks. I mean, whatever you can get it. Because you could find that you've got a very important licensee that's bringing in a huge income. And if it's all based on the patents, you can lose it overnight. But if you've got utility models, if you've got design rights, design patents, anything that you can get, then there will be something left on which to base your royalty revenues. And know-how is very important too.
Know-how, could you expand on that a little when you say
well, know-how is trade secrets. And it's not enough to just say, I have trade secrets, because it's all in my head. That you have to actually manage your trade secrets and your know-how so that you can prove, if you had to, that these have been kept properly secret and they are tangible things. It's not just a whimsical thing, I have know-how. But if you manage know-how right, I mean, you don't have to pay anything for trade secrets and know-how. So all I'm saying is have your registered rights, but remember about the unregistered rights as well, because they can be very important too.
Brilliant. I mean, gosh, that's a huge amount of really rich information. Thank you, Mandy. And really, you sort of touched on my next question. To finish this conversation up, if you could give any advice to young entrepreneurs, many of whom might be interested in social innovation, what might that be? If you can think of anything to expand upon what you've already spoken to us about.
I think the best advice I can give is, before you start with any idea, whether it's a product, whether it's a social enterprise, whatever it is, really do your homework. Really find out whether what you are planning to put all this energy and resource into, whether you have a USP. You've got to have a USP. And that, whatever that is, has got to be something that you're talking about social enterprise, and I'm talking about your market, but it's the same thing. The people that are going to use your product, your service, whatever it is, they've got to really want your service. They've got to really need it, so that when you come out into the market with it, you have good take up. You know, if people have a problem, and your service or your product solves that problem for them, that's fine. But if that problem can be solved in any other way, which doesn't require them to use your product or your service, and is a cheaper way of solving the problem, they're probably not going to use your service or your product. So find out, it comes down to, think of it commercially. It's simpler for me to think of a product. When you do your market research, find out, do people really want your product? Now, it's not, you can do questionnaires, etc., and you can ask people want to please you. They will say, oh, I think it's a great idea. Yes, of course I'd buy that. That is very different to actually putting their hand in their pocket and parting with hard-earned cash. Particularly in days when, people are struggling, which they are at the moment, and they will be for some years to come, I think. They've got to, your product or your service has got to be a no-brainer. It's got to be a must-have. And if you have something which is a must-have and you fulfill that need, protect your product so that somebody else can't just pinch your idea and do it. Protect it, if it's social enterprise, protect your name, your trademark, your domain names. If it's a product, think about what is the appropriate intellectual property. Is it design rights? Is it copyright? Is it a patent? Find out what is essential and try and get more than one type of IP around you. So I think that's it. So I think it all comes down to market research, isn't it? I think that's what I'm saying. Research. The other thing to research is make sure that you're not using somebody else's intellectual property unwittingly. Because I've known of several people that have set up companies, spent a lot of money, they've developed their products, they've established themselves in the market, only to find that the brand that they're using actually infringes somebody else's, or that they're actually using somebody else's intellectual property. They didn't mean to, but that doesn't mean anything in court. Ignorance is not an excuse, unfortunately. So check it all out first.
Brilliant. We've got some really rich insights there, Mandy. Thank you so much. Of course, we can learn more about your career so far and what you're working on now via your website, which I believe is mandyhaberman.com. Is that correct?
Yes, that's right. It doesn't actually talk about what I'm doing right at this minute with Haberman Global Innovations, because that's under wraps until about March. But that's very exciting and not affected by Brexit, which is even better.
Extraordinary.
Yes.
So March, we have to keep our eyes peeled until March.
Yes, yeah, that's right.
Well, thank you so much, Mandy, and I think we'll end then.